Hello, good day. You're welcome to another wonderful segment of sharing good knowledge. And I'm your beautiful host, Elizabeth Moore. Yeah. So we go right ahead to the business of today. Wheel. Last time we talked on a part part of the wheel, which is describing what a wheel is. We talked on some myths surrounding wheel. We also talked on parties of the wheel, which includes the testator, who is the maker of the will, the beneficiary, who are the persons or a person that benefits from the estate of the will. We also talked on executors, but not we didn't really explain that because that was where our 2 minute video ended. That was why I'm going now to go right ahead to give a broader length of time so we can exhaustively discuss what will is about, at least to a great extent, because it's a very broad concept. Now, executors are those trusted persons who is appointed by the testator, persons or person basically, are appointed by the testator to ensure that the benefits of that will is evenly distributed upon his demise. That is, upon his demise, the executor has to be present, or has been elected or has been appointed by the testator, has to be present to ensure that the wishes of the testator in the will is granted. Simple. Now, when they are minors or persons of unsound mind, obviously you know that the work of the executor does not end until that beneficiary who is a minor or of unsound mind has the due like call it the due gift accorded to him or her. Now that guardian who is being appointed, because sometimes you have what they call guardian in a will, and in this case you see that there's a minor or persons of a sound mind who are beneficiaries to the will. And once that happens, you see that the legal guardian takes charge in the overseeing of the affairs of what has been disbursed or allotted to those to those beneficiaries concerned, right? That is for the guardian. Moving on, trustees. These are persons, or when you see trustee in a will, it's not really compulsory. But when you see trustee in a will, the testator is simply electing or appointing a person or an institution to ensure that they manage the affairs of his estate and render account as well as give reports to the beneficiaries of that will. Now, upon his demise, all this happens upon his demise, just so you know. And you have a witness. Let's talk about the attorney first. You have an attorney. You ensure that the attorney is someone who is younger. He's someone who drafts the will and ensure that he lodges the will correctly at the probate, at the prescribed manner, and lodged properly at the probate registry. Now, this lawyer in question must be someone who is young, who definitely will live longer than the testator. You don't want someone who is your age mate to be the one to draft or lodge your will. Got a popular saying that someone who is younger tend to live longer than you, right? So you need a younger lawyer to ensure that the will is properly drafted and lodged at the property registry. Also, you're looking at witness. This this particular party is very, very important in a will because he makes sure that he observes the proceedings or the procedures of that will, from the drafting to the signing to the state of mind of the testator and to the conclusion of that process, all right, to the sealing of the will. The witness has to be there, and the law provides that you must be two witnesses, all right. There must be two witnesses to the will for it to be properly valid. These witnesses must not be blind, must not be deaf. You need someone who is competent enough to come and stand in as a witness also in court. Someone who will see everything that the testator is doing. Someone who will speak, who will listen, that this testator was in his right senses. He wasn't drunk, he wasn't crazy, he wasn't under duress, maybe at gunpoint, or he wasn't influenced by some form of immoral lust in the course of drafting that will. The witness has to be there, and it must not be one. It must not be one, but at least two. It can be 20. It can be a lot. And this witness is very fundamental because it doesn't just observe the state of mind of that person. It makes sure that he personally is competent for that will to be valid. That is why the role of the lawyer is very important because you have to be sure that this particular witness is also an adult. So you don't want a minor to be observing or to be a witness to the will. It must be of a minor and must be of sound mind. Also, the witness must not be a beneficiary to the will. In the event where the witness is a beneficiary to the will, you must ensure that that witness who is a beneficiary to the will must not be a beneficiary in that will, maybe in a codicil. A codicil is like a supplementary will that is being attached to the main principal will. So you can have a supplementary will called a codicil where that witness who had earlier witnessed the first principal will comes to witness and is not a witness in the second codicil, but this time around he is just a beneficiary. That is the only time you can see that a witness is a beneficiary outrightly. But there are also other circumstances where you see a witness becoming a beneficiary to the will. And that is in the case of maybe a trustee, where the witness is given some form of compensation or a gift to act as trustee. In that regard, such a witness obviously is not only the one that is going to be witnessing it, there will be other persons present to witness the procedures to ensure that it is done justly, equitably, and in accordance with the provision of the law, basically. Also, where a witness can be seen as a beneficiary to a will, in the event where, for example, the beneficiary who is a witness, probably the testator is owing me money. Maybe he has bought some properties and he's here to pay. He said, upon my demise, in case I die, please, Mr. A, I was saying that you're witnessing this will. I will give you this car. I'll give you this house. I'll give you this as my and definitely that would definitely be done in the midst of all that witness. So in the event where that witness is owing the testator some money or is indebted to the witness, obviously the status is free, so it does not invalidate that particular will. All right, and definitely that will be done in the midst of other witnesses. So it's safe to have a competent lawyer who is good at this field because some people wouldn't know, and then tomorrow you come to court and they are fighting over the littlest and the most irrelevant things, saying that the will is voidable or is invalid because of the lawyer who is not so grasped in that field made some certain errors. Also, where the witness is married to a beneficiary, in a case like that, obviously that invalidates the will because you will definitely you will definitely want to push positions that will benefit your husband. You get my point. So it's best you examine these witnesses if they're not having a personal relationship with the beneficiaries in the will. You get you just have independent people that have no business and they must be ready and available to be beckoned or called upon to ensure that they're available to be in case the matter gets to court, basically should be available and willing to stand in as surety. They must not be coerced or forced to act in the capacity of a witness. Sorry I'm speaking so fast. Alright. Now I wanted to discuss this concept, but before I go to the concept of next of kin, I wanted to inform you that there are times where the testator, okay, let me first of all talk about the fact where there are times the witness would not be necessarily needed where the person involved, that is the testator, is a military person. Because from my understanding, the best of my understanding, military personnel they have military will as part of their requirements, you know. So, and they don't really look at if you're a minor or not, because in the military then you see some people back then, but though now there's a required age, but then they usually any young boy can come and join the military. And there was a time like that. You get, but now you don't have that. Regardless of that provision, you ensure that whoever is making that way that is a military personnel. Oh my God! Don't tell me I'm